Then I have to issue, file for notices to be issued, my lord.
Item number?
10, my lord. 10 is the IA and it's with a REAT appeal, my lord, REC appeal.
What is your prayer in the IA?
In the IA, my lord, what had happened was in my main case, I said that this construction was so bad. On the last earthquake of 5.6, there were 33 new cracks. The building has sunk 1.5 foot and it has leaned 4 inches, my lord. Plus, there are numerous other problems like leaking pipes, and the building is not even 2 years old. So the structural integrity is at stake, and under 21, Article 21, risk to our lives, my lord. To those who live in the building, this is like a death trap. So that was not looked into by RERA or yet, saying landowner is also like a promoter, but we have not signed a joint development agreement. We are coming under the provision of Section 2 of the RERA Act, whereby we are, as an individual also, we can file against the builder promoter. You are for 12.
I am for 11.
11, 12.
Yes.
He has a similar thing about the.
Your Lordship, I'll submit. Your Lordship, initially what had happened was that item
No, you are
11
in
and 12
item
we had
number?
filed.
You are in item number?
11 and 12. RERA appeal 3
No,
and...
now we are taking up the item number 10.
10,
Yes,
madam.
yes. Your Lordship, what has happened is these two matters were tagged together. However, today, this new item number 10 has also been tagged together. So we were not aware that item number 10 has been tagged with 11 and 12.
It's
Our-
orders.
no, it's no issue.
It's in orders only.
Yes,
no?
so what has happened is our matter is fixed for admission hearing, whereas this is yet to notice is yet to be issued. Because of that, our matter will get delayed, Your Lordship.
No,
I
we
pray
can
that
speed it up.
matters be
We can do dusty service if required, because the question is we should not have conflicting judgments. Judgments given in him, suppose it's for
No. Any
the owner, and my judgment is against.
Your
So
Lordship,
we'll
if
be
my
having-
judgment is passed earlier.
Please sit down. Let me first pass order in this IA.
Yes,
Milord.
Please sit down.
So my prayer over here is that I may be allowed to issue, take steps to issue notice within a week. And if this matter could be fixed on 21st of April, because 6 weeks will be over by that time, as required for the notice. One more second prayer is there, my lord. Since the wires of the act is there, in some states, they have accepted that the landowner can file the case against the builder promoter even without the joint development agreement. In Assam, my lord, as observed by the REAT, a notification by government of Assam is required should the landowner want to file. Now, we are not aware of any such notifications, so state government may be required to be pleaded as a party, my lord, in both the cases. So we both are landowners who have filed against the builder promoter. There's notice and everything has been issued in their case, service is completed, but I'm one step behind, my lord. In the IA, I have annexed the photographs of the damages caused after the last earthquake, where the epicenter was in Morigaon. And I'd also issued notice to the builder, which I hadn't got a reply. Subsequently, they may want to file some affidavit before this court and annex any reply that they may have filed. The main RERA appeal, of course, is against the REAT. The last page of the REAT judgment says that our appeal fails as we don't fall within the structure of the RERA. That, my lord, would find, because if one looks at the annexure, my lord, in the RERA appeal 10, the annexure is at page 90, my lord. Page 90, just before the signature of the chairperson on the third last paragraph, just above paragraph 15. He says that on the basis of the fact
No,
pleaded, does not fall. Is my lordship at page 90? Should I follow my lordship's pencil? Page 90 of the RERA appeal 10 of 25, my lord. Main appeal.
The appeal is yet to be admitted.
My lord, it's
Item
yet to be
number 10
admitted, but notice is yet to be issued, my lord. So today, my one prayer is that the notice I may be allowed to take steps in a week. Let the matter be listed on 21st of April for hearing, admission and disposal if possible. And in the meantime, they may be allowed to
No,
file their response.
you, Mr. Chaudhary,
PN Chaudhary, my lord.
PN Chaudhary, you want to bring on record
My lord, the record
some
of
of
the
the
lower court,
documents in this IA.
the lower court records will also be required, my lord. But
No, that will be
that's done
required,
at a later
definitely
stage.
required.
So IA and in the main RERA appeal, both notices may be allowed to be issued, my lord. Steps I'll take within a week.
No.
My lordship also would, in the fitness of the judicial right, my lord, if the state of Assam can also be made a party, pleaded as a party.
Mr. Chaudhary, you say by filing this interlocutory application, you only want to bring on record some of the documents.
Certain pictorial.
That's all right.
That's all.
But except that there is no other pair in
There is no
fact.
other prayer, my lord, because what has happened is after RERA and all that, we had a earthquake of 5.6 magnitude after
that's
filing
all
of
right,
this.
that's right.
So after filing, these are the post points which have to be brought to my lordship's
You
notice.
say, is there any necessity of issuing notice in this IA?
If my lordship feels it's not necessary, we can go to the main RERA appeal and go on merits, my lord.
Yes.
This is just to bring to my lordship's notice that whatever we had predicted in the RERA case and the RERA appeal has come true now. The building is so badly constructed that post construction, even with handing over and whatever they say,
No,
there is
Mr.
still
Chaudhary,
track coming and endangering the lives of the people.
No,
The
that's all
33
right, Mr.
flats in-
Chaudhary.
My lord.
This item number 10. No, sorry. This RERA appeal number 10,
My lord.
2025, it is yet to be admitted.
Yet to be admitted, notice is yet to be issued also, my lord.
Yes.
So we can issue
This will
notice
be
on
issued
that.
only after admission of the matter.
My lord, let's issue notice then. If my lordship's permission.
Heard Mr. P.N. Chaudhary, petitioner in person, no, appellant in person. And you were here in this item number
11 and
11 and 12.
Our matter is also yet to be admitted. So our matter is also yet to be admitted. It has not been admitted yet. The delay was condoned. After that, the matter is yet to be admitted. So I pray that the matter.
Oh, sorry.
You have filed Ugalat Nama here?
Surrounded by.
Yes, we have filed. 11 and 12.
You
11
are
and
for the
12.
respondent.
And
or the-
also heard Mr. Your name please?
You're for the,
K. Deka,
you're for the
learned
respondent?
counsel for the respondents.
He's also for the petitioner.
This
Petitioner.
appeal under section 58 of the Real Estate within bracket Regulation and Development Act 2016 is directed against the judgment and order dated 28 May
I haven't seen you in
2025
the court before.
passed by the Learned Assam Real Estate
I've been here
Appellate
for
Tribunal
37 years back. I think
Gauhati.
Supreme Court in field.
in Riet stroke Assam stroke appeal number 2 of 2025.
You may be knowing my classmates Manmohan and Koteshwar.
2025.
Can't get what it is. Can you make out what it is?
This second appeal under section 100 of the Code of Civil Procedure. This to be noted here that by the impugned judgment and order dated so and so, the Learned Tribunal has dismissed
Riat Asim appeal number 2 of 25, my lord. My lordship would find that in the synopsis, page 2. Page 2, first line starting with therefore present appeal is preferred by the appellants against the impugned judgment and order. 28th May 25 passed by the Appellate Tribunal in Riyadh, Assam, Appeal number 225, where the appellate dismissed the upheld the judgment 5th of December 25 passed by RERA below in RERA complaint number RERA Assam complaint 2310.
কি করলো last line তো? হুম। Thereby affirm the judgment passed by the learned RERA by the learned real estate real estate where is that judgment?
The judgment, my lord, would find it at page 63 to 70. The RERA judgment of 5th December 24.
Real
63
Estate
to
Regulatory
70.
Authority Assam dated
The
5
operative part is at page 17.
2024. It is to be noted here that by the MP on judgment and order dated 5/12/2024, the learned Real Estate Regulatory Authority Assam has dismissed
Dismissed our
the complaint
complaint.
filed by the appellant herein being not maintainable before the authority. Here is the memo of appeal and the grounds mentioned therein. And also, here is the substantial question of law. Where you have mentioned the substantial question of law?
My lord, I bring my lordship to that. Lordship would turn to page 17 of the RERA appeal 10. If my lordship is at page 17. Have I brought my lordship to page 17?
Yes, yes.
At para H, substantial question of law that arises. It's as many as 14 have been drafted, my lord.
So, the regulatory authority has held that complainant is not an allottee in terms of section 2D
My lord, and if my lordship would,
of the Real Estate Regulation
my lord,
and Development Act 2016
my lord, and what
and is
was,
not covered under section 31, subsection 1 of the said act.
my lord,
And as such, the complaint is not maintainable before the authority.
my lord, what was ignored, my lord, was section 2ZG small, where person includes subpara 1 an individual. That has been upheld by the Orissa High Court, my lord. So either as a landowner or as an individual, the act itself is wide enough in its scope to bring the builder to boot.
You are referring to section Z.
Z small g, my lord, in the Real Estate Act of 2016, under the section 2, which is of definitions 2Z and G, person. Person includes subsection 1 an individual. So they have overlooked this, and in fact, I am an allottee, my lord. So an allottee also comes, my lord, at section 2D. Section 2D is an allottee where I may not have executed a title sale, but I've been given a share in the property in lieu of the fact that I'm a pattadar, landowner. Now, in this case, what happened, an MOU was signed, which came to an end in the year 2018.
No, the question is whether section 2D covers the landowner.
2D, my lord, covers the landowner as an allottee. That is where the question arose. An allottee, we don't have to file, title deed is not there for, say, by way of sale. In value of my land, I get property, real estate, and covered area, and whatever. I get a property built up because I may not have the finances to build the property. So I approach a builder. Then it is my land which he agrees to promote. So the documents are signed. It could be an MOU, it could be a contractual deed, it could be anything, but a power attorney is also executed. Now, in this case, we signed an MOU and gave them 4 years, that is from 2014 to 2018, to build an 8-story construction. They showed us the plans. Instead, they made a 6-story construction, and they did not give us the occupation certificate. So when we filed before the RERA, at that time, they produced an occupation certificate, which was in 24. Certain documents also which were asked for, like the structural integrity of the building, architectural plans, approved architectural plans, they were not given. They claimed that these documents were given to the ad hoc society. When we asked the ad hoc society, the signatures which were shown to us in the court, those signatures belong to the society created by the builder himself. So we don't know
Okay,
who the builder.
do you have the decision of that Orissa High Court which you have referred to?
I have it in soft copy, my lord. I'll give the hard copy to the reader.
Okay, then we have to go through the same. Today we will not pass any order.
Then we can have it next week, my lord. I'll give the hard copies to my lordship.
You
Today being
forward it-
Thursday, if you can place it
No,
on
you
Tuesday.
forward it to the court master. We will get it.
My lord,
confirmed.
my lord, my lord,
We reserve the order today.
my lord. My friend has something to say about his cases.
11 and 12, it's a
Yes, let me
slightly
get
different issue because the facts are slightly
Let me
different.
just get out.
The core issue is the same, Lordship, with regard to whether a landowner can be an allottee or not. However, in my case, Lordship, item 11 and 12, there are the learned appellate tribunal has given no findings with regard to the fact that I have an allotment agreement. Secondly, the learned appellate tribunal has given no finding with regard to the fact that there are specific violations of the provisions of the Act, which I have specifically pleaded in my complaint, and it was specifically pleaded in the there is a status report which is backed by my complaint, which specifically states that there are certain violations of the Lordship, the structural or the proposed plans. Lordship, if you Lordship, may I kindly have appeal number 3. Lordship, in appeal number 3, Lordship may kindly have page 87. It's my complaint before the Honorable RERA. And Lordship may kindly have my prayer.
No, you said none of the appeals are admitted.
Yes, sir. No, Lordship, only
Today,
without the
without,
question of law, Lordship, I'm just making my case. Because in my Lordship, in my case also, the learned appellate tribunal has have not given a finding by omitting to observe about the allotment agreement. I have 2 agreements. One is builder buyer agreement. Secondly, the allotment agreement. So the learned appellate tribunal has have given no finding with regard to the allotment agreement, Lordship. And I specifically fall under the definition of section 2D of the allottee, Lordship. Lordship may kindly have section 2D for once. And in a similar issue, Lordship,
sir, order reserved, recessal list the matter on COVID, things and that. 2nd of March. Mr. Sodore, we will list the matter on 2nd of March. Your matter, both IA and the appeal. In IA, you take down.
Your
Part
Lordship, can it
is
be on 3rd of March?
11 and 12.
learned counsel for the applicant. This application is filed under Order 41 Rule 2, read with Section 151, Section 150 CBC to bring certain factual metrics on record that have arisen after 10th of March 2023 as part of the record. Recessal list this matter along with RERA appeal number 10 of 2025. That's soft copy to লৈ ল'ব এইটো। Mr. Sodhuri, you are not a party in appeal number 3 and 7.
Not with them.
No. Okay, you can leave now.
I would like.
So you have suggested as many as 4 substantial question of law.
Yes, Lordship. Lordship, however,
Which one according to you is relevant here?
Lordship, only A, B, and C, Lordship. And Lordship,
Only?
A, B, and C in RERA appeal number 3. The first one is to determine whether my allotment agreement has been considered or not. And secondly, to show that there has been violations of the provisions of the Act, which has not been considered by the learned appellate tribunal, Lordship. Lordship, there
So
is
there's a question number 1
Yes,
that
Lord.
was dealt with by the regulatory authority and also by the tribunal.
The regulatory authority has held that I am an allottee, but the tribunal has said that I am not an allottee, and the tribunal has not considered my allotment agreement because there are 2 agreements. One is development agreement, and the second is the allotment agreement. The regulatory authority, by considering the allotment agreement, has stated that I am an allottee falling under the definition of 2D because in my case the property or the flat was transferred. Lordship, in section 2D, there are 3 criteria: ownership, sale, and transfer. So in my case, the property has been allotted me by a way of transfer in consideration of the land which has been given by me. So there is non-consideration of the allotment agreement by the appellate tribunal. And secondly, there is a status report from the municipality board which specifically says that the occupancy certificate was not given or it was rejected, which is a specific violation of the provisions of the Act, which was not considered by the appellate tribunal. And Lordship may kindly have para 14 of the appellate tribunal observation, which says that there is no violation of the provisions of the Act. However, Lordship may kindly see the status report for once. It says that the occupancy certificate has been rejected or the completion certificate has been rejected, and which is a specific violation of section 11(4)(d) of the Act. Because it is the duty of the promoter to grant the occupancy certificate. Lordship, in a similar issue, there is a judgment of Kerala High Court where the maintainability of whether a landowner can, a petition filed by a landowner can be maintainable or not. In a similar issue, it was a section 17 thing. The Kerala High Court has held that yes, landowner on the basis of an agreement, allotment agreement and a builder buyer agreement based on Bunga Daniel judgment has said that landowner's complaint is maintainable. Lordship may kindly have this Kerala High Court judgment. If your Lordship may. Issue Lordship 2.1 is relevant for our case. 2.1. Para 2.1. So para 13 and 14 is the main element observations. Para 13 and 14 of the document.
Okay. In item number 12 is also same.
12 and yes, sir. 12 is for the commercial area, which was to be given as per the same agreement, and 11 is for the flats. So
Okay. We'll see, we'll pass the order.
Lordship.
Heard, Mr. Your name, please?
K Deka, Krishna.
Learned counsel for the appellant in appeal number 3
and 7. Appeal
3
number
and 7.
3 and 7.
Your name is not reflected in the cause list.
Your Lordship, what has happened is his name is not in the CIS. My name is there, C Google. His name, his sign is in the Vakalatnama, but it does not get reflected in the cause list.
The learned counsel submits that his name is not reflected in the color in the cause list. Accordingly, it is provided that shall do the needful in this regard. Heard, Mr. Swenson, learned counsel for the appellant. Order reserved.
Lordship. Lordship, I tender my sincere apologies. When the item number 9 was called for, I
Take a date from him.
Item 13.
I'm paying for 10 days time, file my objection in the IA matter.
Absolutely. It's there in the record. I cross check. So they said it has come. My
You
lord,
want to file objection?
Only 1 week, my lord. 1 week time.
my lord, what has happened, my lord, the appeal has been admitted, my lord, on the last occasion. But on the consideration of the stay application, my lord, it was the view of the honorable bench, my lord, that as execution case has not been filed, so stay will not be considered on that occasion. But subsequently, execution proceeding has been initiated. I have filed an additional affidavit, my lord, thereby bringing on record the certified copies of the execution petition as well as the order passed. So the execution case is fixed on 21st of this month, my lord. As such, I pray for a stay of the appeal. The order.
No, that
in order.
execution proceeding is fixed on 21st.
Yes, ma'am.
For
It has been reflected for hearing on petition number 661/2026, my lord.
okay. On that day, no adverse order,
lord,
I think, will be passed against you. Let him file objection. Yeah.
My lord, what has happened, like, if no stay is granted, my lord, the lower honorable trial court, they will not, they may proceed with the matter. I'm not
No,
aware of
next date is fixed for consideration of the application.
application, my lord, some petition 661/2026. What is that petition? I'm not aware, my lord. My lord,
Yes,
as the
what is
appeal
that
is
petition?
admitted, my lord.
I recently filed my Vakalat. I will also file with the execution case. I protect his time.
My lord, as the appeal is admitted, judicial, my lord, propriety demands, my lord, that may be stayed, my lord. Because appeal has been admitted, lord, my subsequent questions of law have been formulated on the last occasion.
Maybe,
Sorry,
maybe.
yes, my lord. But if the execution proceeds, then multiple.
No, we are not dismissing your application.
Yes, my lord.
You want to file objection, let him file. We'll fix a short date.
Ordered, my lord, but no adverse order may be passed in the execution. That may be reflected, my lord.
No, that
is
kind of
some-
injunction cannot be given here. Heard Mr. Borua, learned counsel for the applicant. Mr. Borua submits that he has filed one additional affidavit,
Yes, ma'am.
but the same has not been placed on record. On the other hand, Mr.
Mr.
R.S. Mr. learned counsel for the respondent submits that he may be granted some time to file objection. Where allowed, recess shall list the matter on next no, short date. Next week. Okay, 26.
Madam. Conducting Senegal is another good for the time being, Lordship.
Next.
I got for admission. I don't know both 1 and 2.
Lordship, I was praying that the selection process that was undertaken, Lordship, that may be finalized, Lordship. And my friend was required to obtain instruction as to whether if this finalized under the provisions of the old Act, Lordship, what would be the consequence, Lordship?
So that process has been stayed by this court.
Lordship, the select list, the panel that was prepared by the school selection committee, that was kept under sealed cover, Lordship. And subsequently, by this, there is an order of this court, Lordship. In 2024, that was open, Lordship. And it has to be sent to the state selection board thereafter, Lordship. And that has not been done till now. State selection board
So,
will prepare a list.
So your pair is that the selection process initiated, has to be taken to its logical conclusion.
Lordship.
That is your pair.
Yes, Lordship.
Yes, Mr. Doctor.
Lordship. Look, Lordship, actually, Lordship, review was held on 14/12/2016, Lordship.
No, who is the final authority? Who will conduct the selection? State selection board?
No, Lordship, thereafter, Lordship, another one tier, Lordship, which are in government to verify and to consider whether the approval will be granted or not. After consideration and verification, the government will have to give the approval. What happened, Lordship, in this case? Initially, interview was held on 14/12/2016, Lordship. That interview was put on challenge in petition number 1296. As violation of constitution of the state selection board, school selection board. This honorable court has directed the director to go for an interview in compliance with the guidelines and by constituting a selection committee as per law, Lordship. Thereafter, Lordship, the second interview was notified. That interview was put in challenge before in this petition, Lordship. As per order of this honorable court, this petitioner has participated and it was also directed that it would be subject to outcome of the petition and the result of selection would be kept on seal cover. The second interview, Lordship. That in the second interview, Lordship, when the seal cover was opened before this honorable court, the petitioner secured the third position, Lordship, in the empanelment of the three candidates. So if that selection is to be finalized, the petitioner would have no case. First thing, Lordship. And second thing, Lordship, the government is now contemplating in this process of Lordship selection to go for a fresh selection in terms of the new amended rule, Lordship, 2018 rule, Lordship.
No, earlier selection process was initiated as per earlier rule.
Earlier rule, Lordship,
So
2003
that has to be taken to its logical conclusion.
no, that first interview, Lordship, where the petitioner selected as the first candidate, that was rejected by the government, Lordship.
No,
His
that's
name
all
was-
right. The second one,
The second one, he was in a third empanel candidate, Lordship.
all right.
And in the second one also, Lordship, after that selection, Lordship, by school selection committee, the matter has to be placed before the state selection board. At that stage, Lordship, the government has taken a policy decision to discontinue the selection and to go for a fresh appointment. As because this present case is pending before this honorable court, the government is not taking any decision, Lordship, for in order for judicial discipline only, Lordship. This is, Lordship, one my instruction and I have pleaded in my affidavit in opposition also.
So since the present proceeding is initiated under the earlier set of rules, so you have to taken it to its logical conclusion as per the prevailing rule at the relevant point of time.
There is some lordship differences his opinion in various High Court as well as the Supreme Court has held that the date when the consideration would be take place would be governed. Even in the repeal act, if he has some right, but that's the right to be vanished after coming into the new present act when the government has taken the policy decision. It is lordship, if lordship permit, I can place one judgment of this honorable court referring as Supreme Court judgment. Lordship, that petition number 657/6 of the 2022 shows Shah Sikandar Ali lordship. Lordship would find that relevant, but here lordship in fact is just the promotion from gate for to lordship under the old rule he was claiming. Lordship, I'm just lordship paragraph 17 lordship. Lordship got it. The provision of Rule 41 is accepted here and would go to reveal that the post of renewal assistant of government has been equal to be filled up by a back only. No provision has been shown. At this stage, 18 losses, it is to be noted that the Honorable Supreme Court, in the case of Himachal Pradesh and others, such as Rajkumar and others, reported in showing so, after discussing the earlier case on the issue, more particular the decision of Honorable Appellate Court in YV Rangia Vices and others, Vices J. Srinivasan Rao reported in 1983 3 SCC 282 concluded that a review of the 15 cases that have been distinguished Rangia would be demonstrated that this court has been consistently carving out exception to the broad proposition formulated in Rangia. The finding of this judgment that had to be direct bearing in the provision formulated in RS under 1 28.1. There is no rule of universal application that vacancies must be necessarily be filled on the basis of law which existed on the date when they arose. Rangia case must be understood in the context of the rule involved therein. It is now a well-settled proposition of law that a candidate has a right to be considered in the light of existing rule, which implies that rule in force on the date of consideration takes place. The right to be considered for promotion occurs on the date of consideration of the eligible candidate. The government is entitled to take a conscious policy decision not to fill up the vacancies arising prior to amendment of that rule. The employee does not require any vested right to being considered for promotion in accordance with the repeal rule in view of the policy decision taken by the government. There is no obligation for the government to make appointment as per old rule in the event of restructuring the cadre is intended to be efficiency working of the limit. The only requirement is that the policy decision of the government must be fair.
Mr. Dutta,
Lordship.
you furnish the citation to Mr. Sharma. Let him go through the judgment.
Lordship, my submission would be that Rangia is on a different context altogether, Lordship.
Pardon?
That the citation cited in that Supreme Court one, Lordship. Rangia is on a different context altogether, Lordship. That relates to the filling up of the vacancies of the year, Lordship, and the rules persisting at that point of time when the vacancies occurred, Lordship.
Have you gone through the decision?
That Rangia one I am saying, Lordship, with regard to that Rangia, Lordship. As basing upon that, this judgment has probably been passed, Lordship.
No, the subsequent decision of the Supreme Court in Himachal Pradesh and others versus Rajkumar and others.
That I have not.
You go through the same. We'll fix another day. You furnish the citation to me. Heard Mr. MP Sharma, learned counsel for the petitioner, and also heard Mr. P.P. Dotto, learned standing counsel for the respondent in Secondary Education Department, Mr. Nandi for the respondent number 5 in WPC number 4225 of 2019, Mr. K. Uddin, learned counsel for the respondent number 5 in WPC number 2847 of 2019. You for? Mr. Alam for NCT. Respondent number 18, WPC number 2847 of 2019. During the course of hearing, Mr. Dotto has referred to a decision of Honorable Supreme Court, based on which he argued that at the time of consideration of the promotion, the rule prevailing at the time of consideration has to be taken into account. Let a copy of the judgment be furnished to Mr. Sharma, learned counsel for the petitioner, so as to enable him to answer the same on next date. List the matter on. First week of March.
Lordship. Lordship. Lordship will keep it at part heard. Keep it as.
Recessal, list the matter as part.
Obliged, Lordship.
Six.
May it please, your Lordship. Lordship, in this matter, I am seeking an adjournment today, Lordship. Let a matter come up after 3 weeks, Lordship.
Why?
Lordship, they have filed an affidavit in this matter. So that has also not come on record.
That is not on record. We filed it on 17th.
Okay.
Still not on record.
And
Heard Mr. C. Sharma, learned counsel for the petitioner, and Mr. A. Biswas, learned counsel for the respondent number 1, 2, 3, and 4. Mr. Biswas, you see, this civil revision petition is directed against one order. Where is the provision for filing affidavit?
There is no, but we sought for a leave to place on record the actual facts, your Lordship. Because what has happened is, the order which was passed by the learned trial court was with regard to calling of some documents. They wanted to, because this is a landlord-tenant dispute.
Hmm.
I am for the landlord, and they had exhibited the NJ records, against which we had even cross-examined the deponent, the defendants on the NJ records.
Hmm.
Now, after the witnesses of both the sides were over, they wanted to bring from the Siestadar the original records of subsequent payments made by them. Now, our contention before the trial court was that this, on the petition, we said that this was not required because let the matter be argued if the trial court feels that some documents may be looked into, because cross was over on the documents which they had already exhibited with regard to the NJ records they had filed.
No, Mr. Biswas, you say in this petition we are testing the correctness or otherwise of the impugned order. So what is there in the order we have to see?
Yes.
So whether any document placed beyond that order, can we look into here?
No, that is true. I just had placed on record, it is not a
Okay,
thing that
alright.
is allowed.
Mr. Biswas, learned counsel for the respondent submits that he has filed on affidavit, but the same has not been placed on record. Mr. Sharma also submits that. You have received the copy,
yes, Lordship.
that
We have-
he has
we had
received the
given the
copy.
17th.
Received the copy, and he may be granted some time to go through the same parallel. Recessal is the matter after a week. Enclosing the affidavit filed by Mr. Biswas, learned counsel for the respondent.
Lordship, can it come after 3 weeks, Lordship? Can it come after 3 weeks, Lordship?
After 3 weeks. Correct.
Obliged, Lordship. Lordship, there was a stay, Lordship. Till the next.
Interim order personally shall continue.
Obliged, Lordship.
For hearing item 14.
May I please, your Lordship?
Hmm.
Lordship, in this case, Lordship, appellant has taken brief from us, Lordship. Appellant, Lordship, taken brief from us, Lordship.
Okay.
On several occasions, the appellant is then or taking time grounds.
This is
So,
of
can we
2010
see the
matter.
last of it?
2010 matter. Heard, Mr. Your name, please?
P. Sharma on behalf of OP Party.
B. Sharma, learned counsel. appearing on behalf of Mr. O.P. Bhatil, learned conducting counsel for the appellant, and also heard Mr. A.C. Sharma, learned senior counsel, assisted by Mr. learned counsel for the respondent. Mr. Sharma submits that the appellant has taken back the file from him, but the appellant remain unrepresented today, and in that view of the matter, it is provided that res disal issue notice to the appellant.
They have to first. No, they have to withdraw from the case. They are not withdrawing from the case. They have stated their file has been taken.
We are
They
not,
have to file it.
we are not long-
But this court that we are withdrawing from the case. Then
Yes.
it is establishment notice.
we are,
Okay. Okay.
Therefore, there is a lapse on the part of the appellant. Your logically say, on the last occasion, appropriate order will be passed if they took time.
Mm.
And as they have not taken it, it will be dismissed for default. Because suit is this, but I purchase the land from that. And they find the suit that my sale deed is, I fraudulently obtained that sale deed. The trial court decreed that suit, but the appellate court here, then the sale deed is valid and genuine. I purchase the land from them, they find the suit that I have taken the sale deed fraudulently. And Landlord law appellate court dismiss their case, it's that they have no merit in the case.
No, that's all right. Today we are not considering merit of the case. Okay, you file an application here. The learned counsel appearing on behalf of Mr. O.P. Bhatti submits that he will file an application to that effect before this court and press for granting some time where allowed. This is the matter on. We'll fix it that cover next week. 26. 26.
Worship, I apologize for not being here. I
Huh?
apologize for not being here on the
Oh,
matter.
no, not online, not online.
Lordship, by way of this review petition, I'm praying for a review of the order passed by your Lordship on 8/6/2025 in CRP IO 108 of 25, which your Lordship will find at page 127. Now, the brief background of the case is that Lordship, the predecessors of the petitioner here preferred a suit claiming for right title and interest over a scheduled plot of land, which was purchased by him in 1981, and later on the land was mutated in his name on 13/12/1991. When the suit was filed, after the suit was filed, the defendant entered appearance, he filed a written statement, there was a counterclaim as well. But during the pendency of the suit, he expired. When he expired, Lordship, his sons were impleaded, substituted, but they did not contest the suit, and a ex parte decree was passed in my favor. After passing of the decree, ex parte decree, Lordship, I filed a title execution case, which was title execution 5 of 2018. Notices were served upon the defendants, that means the judgment debtors, and one judgment debtor, Lachit Guala, he appeared and prayed time to file objection. Thereafter, the respondent hearing on 6/12/2018, She filed a petition under Order 9 Rule 13, praying for setting aside the ex parte decree and to add her as a defendant counterclaimant in the suit. And this was, Lordship, done after a period of 13 months and 14 days. There was no petition for condonation of delay. And it was rejected on 24/10/2019. Against that rejection, Lordship, the respondent herein filed a miscellaneous appeal, which was registered as Miss Appeal 4 of 2019. And that was also dismissed by order dated 16/7/2024.
Mm.
And it was observed that while filing the petition, there was no endeavor on her part to prove that she was indeed the legal heir of late Hori Gwala, who had predeceased,
Mm.
and without and that without her presence, the judgment and decree was bad in law. After dismissal of the Miss Appeal, she filed a petition in the execution case under Order 29, Rule 97 and 99,
Mm.
which was registered as Miss J case 37 of 24.
Mm.
And the same was allowed by the court by order dated 5/2/25.
Mm.
And the respondent was given the privilege of filing the evidence.
Mm.
Aggrieved by that, the petitioners herein filed a CRP IO before this honorable court,
Mm.
which your lordship decided by order dated 6/8/2025.
Mm.
And the operative portion, if I may just read, lordship,
Mm.
lordship had relied upon the judgment passed by the Honorable Supreme Court in Brahmadev Chaudhary versus Rishikesh Prasad Jaiswal, reported in 1997, 3 SCC, which your lordship will find at page 130. If your lordship will just for a moment, I'm just taking your lordship through the contents. Paragraph 6, which your lordship has quoted,
Mm.
on the undisputed facts on record,
Mm.
it has therefore to be held that because of resistance or obstruction offered by the appellant,
Mm.
amongst others, on 28/4/1991, the application moved by the respondent decree holder. Lordship will please note that the respondent was the decree holder and the appellant was the person who obstructed.
Mm.
Moved by the respondent decree holder on 6/5/1991 was necessary to be one falling within the scope and ambit of Order 21 Rule 97. It is pertinent to note that the resistance and or obstruction to possession of immovable property as contemplated under Order 21 Rule 97 could have been offered by any person. The words any person as contemplated by Order 21 Rule 97 Subrule 1 are comprehensive enough to include, apart from the judgment debtor or anyone claiming through him, even persons claiming independently and who would therefore be total strangers to the decree. Now, if I may take your lordship to Order 21, Rule 97.
Mm. No, Mr. Sodhure, you say the decision of this court is based on the decision of the Supreme Court in the case of Brahmadev Sodhure,
Lordship.
right? So on the other day, you have submitted that this decision was
Now, this has been again explained in a later case, which
where is that decision?
I have got a copy, lordship. But lordship, let me first take your lordship through the.
No, that's all right. Our main contention is based on the decision of Supreme Court in Brahmadev Sodhure.
That perhaps why I say that perhaps lordship maybe something happened, lordship. A petition under Order 21 Rule 97 is maintainable only by the decree holder.
Hmm.
Here was a petition
Hmm.
filed by a stranger who is not a decree holder.
Hmm.
Now,
No, that was explained in the Brahmadev Chaudhary case.
no, that was again explained
Hmm.
in a later case, which I
Hmm.
want to show your lordship.
Hmm.
If I may take your lordship
Hmm.
to page 5 of that judgment at paragraph 9. Now, who can maintain a application under order 21, rule 97? Paragraph 5. At the outset, we may observe that it is difficult to agree with the High Court that resistance or obstruction.
Which one you were reading?
I am reading paragraph 9 at page 5 of that judgment I have given lordship.
Okay.
Citation.
Hmm.
1998 3 SCC 723.
Hmm. Yes.
98 3 SCC 723. At the outset, we may observe that it is difficult to agree with the High Court that resistance or obstruction made by a third party to a decree of execution cannot be gone into under Order 21, Rule 97 of the Code. That's right. Rules 97 to 106 in Order 21 of the Code are subsumed under the caption resistance to delivery of possession to decree holder or purchaser. Purchaser is an auction purchaser.
Hmm.
Those rules are intended to deal with every sort of resistance or obstruction offered by any person. Rule 97 specifically provides that when the holder of a decree for possession of immovable property is resisted or obstructed by any person in obtaining possession of the property, such decree holder has to make an application complaining of the resistance or obstruction. Subrule 2 makes it incumbent on the court to proceed to adjudicate upon such complaint in accordance with the procedure laid down. Now, the application, if I had gone to take possession, I have been resisted, then I have to file an application. Lordship, subject to my understanding, Lordship, Now, here is a case where the opposite party files an application. Here is a case where the opposite party has filed an application and who is obstructing me. Now, an application under Rule 97 is maintainable only by the decree holder. The statute also says so.
No. That any person, word any person, that
Yes,
has
yes.
been interpreted in the case of Brahmadev Chaudhary.
Yes, Lordship. Any person may be any person who is obstructing me. But that any person, the obstructor, cannot file that application. Because the decree is in my favor. I go to take possession of a plot of land, I am obstructed, and only I can file that application under Order 21, Rule 97. And this position has further been explained in another case, that is, of course, of the Kerala High Court. But Lordship may have a look. Where Brahmadev Chaudhary has also been discussed. In my copy, I have given. This is longer. Here, if I may take your lordship to page 3, paragraph 4 and 5.
Yes.
An application under Order 21, Rule 97 can be maintained only by a holder of a decree for possession of immovable property or by an auction purchaser of immovable property in court sale. An obstructor, resister, or a third party cannot maintain an application under that rule. The scheme of Order 21 CPC and the various rules there under are instrumentalities in the hands of the decree holder for execution of a decree, bearing the provision made there under to protect and adjudicate the interest of a third person who is not bound by the decree, such as Rule 58 and right to get a claim adjudicated under that rule. Necessarily, it should be understood that Rule 97, like the provisions under Order 21 CPC, is one of the modes of execution available to a decree holder to execute a decree for possession. If it is not utilized or exhausted in proper cases at proper time, the resultant effect would be the dismissal of the execution proceedings. As such, it is incumbent on the decree holder to apply under Rule 97, Order 21 CPC, where there is obstruction or resistance offered by any person. Also, the next paragraph, lordship, I'm only reading the first few lines. Order 97 would come into play when the holder of a decree for possession of immovable property or a purchaser of any immovable property.
Mr. Sodhuri,
Lordship.
so law is very much clear on this point. So we need not go to the decision of the Kerala High Court.
Lordship.
But the decision of this court is mainly based upon the interpretation of the word any person in the case of Brahmadev Sodhuri.
Lordship.
So you show me the decision where this interpretation has been distinguished or clarified. You have referred another decision of the Supreme Court. In which paragraph it is clarified? You tell me.
No, Lordship, any person, what I am on is who will file the application. Supreme Court has clearly stated that the application can be filed only by the decree holder.
No.
Even in Brahmadev also.
No.
Even
in Brahmadev, you come to paragraph number 6.
Yes. If I may read
Paragraph
it,
number
one second.
6. 1, 3, 5, 6. We start from paragraph now. So line number 9. The word any person as contemplated by Order 21, Rule 97, Sub-Rule 1
Yes.
are comprehensive enough.
Yes.
Include apart from judgment debtor or anyone claiming through him, even person claiming independently, and who would therefore be total stranger to the decree. It is to be, it is not in dispute between the parties that no decree was passed. No decree for possession has been obtained by the respondent number 1 against appellant number 1.
Yes.
He is therefore prima facie a stranger to the decree.
Yes.
So this interpretation, whether it is clarified in any subsequent decision or not.
What I want to submit before your lordship, this case of the Honorable Supreme Court is the other way around. Here is a case where it is the lordship, if I may again read it, the first opening lines will make it very clear. On the undisputed facts on record, it has therefore to be held that because of resistance or obstruction offered by the appellant, amongst others, on 28/4/1991, the application moved by the respondent decree holder.
Hmm.
Here the respondent was the decree holder.
Hmm.
I'm the petitioner plaintiff.
Hmm.
Now, if my learned friend's client would have been the decree holder
Hmm.
and I would have obstructed, then it is perfectly right as
Hmm.
per what has been stated in the Supreme Court judgment.
Hmm.
That is why I say the case decided by the Supreme Court, there the respondent had a decree.
Hmm.
Here, the plaintiff has a decree. So this has to be understood the other way around.
Hmm. No, you see the subsequent lines,
Yes,
the any person,
yes, yes.
the word any person.
Now, keeping in mind
Hmm.
the change situation, because there the respondent was the decree holder, here the petitioner is the decree holder. Under this changed situation, it would be operate. The words any person contemplated under Order 21, Rule 97, Sub-Rule 1 are comprehensive enough to include, apart from the judgment debtor or anyone claiming through him, even persons claiming independently who would therefore be total strangers to the decree. It is not in dispute between the parties that no decree for possession has been obtained by the respondent one
Hmm.
against the appellant.
Hmm.
He is therefore prima facie a stranger to the decree. When he offered obstruction or resistance to the execution of the decree, he would squarely fall within the sweep of the words any person as found under Order 21, Rule 97, Sub-Rule 1.
Hmm.
Now, if I may read it once again, Lordship, if I may read the statute also, Lordship,
Hmm.
please.
No, reading the statute is not required because it is well settled.
Yes, it is well settled.
But the
it
question is this interpretation by the Supreme Court in this judgment.
Yes, Lordship.
Hmm.
And the Supreme Court in a later decision has stated,
Hmm. Where?
which I have just given the silver line, Lordship,
Hmm.
that who will file their application?
Hmm.
Paragraph 9. Who will file that application? It is not by the stranger, it is the decree holder who will file the application under Order 21, Rule 97.
Sorry, Lordship, in this particular judgment, my colleague is referring. If your Lordship sees para 16, where Brahmadar Chaudhary has.
Yes, it has been referred.
It has been referred.
I-
In the last part, we are in agreement of this proposition.
Yes,
Para 17, they said.
Hmm.
Brahmadev was the other way around, Lordship.
And they have reiterated what was stated in Brahmadar.
There's nothing
I'm
wrong.
just going through, I didn't go through, I'm going to online. So what I.
Okay. You go through the same.
Yes.
Go to the same. We'll resume after 5 minutes. 12 o'clock.
Yeah. Just go through it.
You have the this hard copy.
I will give him a hard
I'm
copy.
just going
Give a
through
copy
it.
to him.
A hard copy.
We'll resume at 10. Sorry, 12.
What do you say?
Mr. Biswas, you have gone through the decision?
Just going through, it. Your Lordship will find that the citation he has referred to.
Hmm.
In the Supreme, para 15 of that judgment,
Ah,
the para 15,
yes.
here the Lordship's judgment which your Lordship had relied
Yes,
upon,
Hmm.
has been relied upon by the Apex Court again.
Hmm.
And end of that particular para,
Hmm.
they are saying that we are in respectful
Yes.
agreement
There is no,
with the aforesaid proposition.
I have no quarrel with the proposition laid down in
Hmm.
by the Supreme Court.
Hmm.
But your Lordship, after Lordship has referred to paragraph 6,
Hmm.
the same judgment, Brahmadev Lordship, I do not have a hard copy.
Hmm.
I'm referring to the online. After that paragraph, the court has proceeded to adjudicate upon the application in accordance with said order. After that paragraph, the Honorable Supreme Court reads the form,
Hmm.
how the summon has to be issued.
Hmm.
That is number 40, summons to appear and answer charge of obstructing execution of decree order 21 rule 97
Hmm.
to so and so, whereas the decree holder in the above suit has complained
Hmm.
to this court that you have resisted or obstructed the officer charged with the execution of the warrant for possession. You are hereby summoned to appear in this court on so and so date. So thereafter the Supreme Court continues.
Hmm.
It is therefore clear that in an application under Order 21 Rule 97 moved by a decree holder who complains about the resistance or obstructions offered by a person,
Hmm.
by any person to the decree holder in his attempt to obtaining possession of the property and who wants such obstruction or resistance to be removed, which otherwise is an impediment in his way, a lease arises between the decree holder applicant under Order 21 Rule 97 on one hand,
Hmm.
and such obstructionist or resisting party on the other, to whom summons have been issued by the court in as per Form 40. When such a lease arises, it has to be adjudicated upon as enjoined by Order 21 Rule 97 Sub Rule 2. It is therefore very clear that the application, even in Brahmadev, it holds that the application has to be filed by the decree holder when he goes for execution of the decree.
Hmm.
When there is an obstruction,
Hmm.
then the decree holder will file an application and the court issues a notice under Form 40.
Hmm.
The opposite party is given a notice, and thereafter Rule 97(2) will come into force.
Hmm.
Therefore, Lordship, my understanding is,
Hmm.
Lordship, there is no quarrel with the proposition laid down in Brahmadev.
Hmm.
Brahmadev, what is confusing is Brahmadev, the respondent party was the decree holder.
No, that's all right. We are concerned with the interpretation of the word any person.
Yes. Here,
That is.
Brahmadev did not say
Hmm.
that any person would be them.
No. Here it says any person includes the stranger also.
Yes, any person who will resist me.
Hmm.
But here, before I am being resisted, the opposite party files an application,
Hmm.
which in my humble submission is not maintainable, Lordship.
Hmm.
And even if for persuasive value, if I may take your Lordship to the judgment in the Kerala High Court,
Hmm.
if your Lordship will come to page 5, Brahmadev has been referred to, and then the other case has also been referred to here. In Silver Lining, the Supreme Court decision which I have given your Lordship, subsequently, paragraph 9 of that Kerala High Court judgment. Subsequently, another larger bench, 3-judge bench of the Apex Court in Silver Line Forum versus so and so, has laid down the legal position that it is the decree holder who has to make an application complaining of resistance or obstruction, and also settle the legal position that it will be well within the jurisdiction of the executing court under Rule 97(2) read with Rule 101 of Order 21 CPC to adjudicate the dispute raised by the obstructor resister in the following lines. Resistance or obstruction made even by a third party to the execution of a decree. Now here is a third party. Can be gone into under Order 21 Rule 97. Rules 97 to 106 in Order 21 are subsumed under the caption resistance to delivery of possession to the decree holder or purchaser. I'm the decree holder. Those rules are intended to deal with every sort of resistance or obstructions offered by any person. Rule 97 specifically provides that when the holder of a decree for possession of immovable property is resisted or obstructed by any person, when the holder of a decree is resisted or obstructed by any person in obtaining possession of the property, such decree holder has to make an application complaining of the resistance or obstruction. Subrule 2 makes it incumbent on the court to proceed to adjudicate the upon such complaint
Hmm.
in accordance with the procedure laid down.
Hmm.
Now, she is a stranger. She is the third party.
No,
She is,
Mr. Sodre,
Lordship.
very recently, because of this position, Supreme Court has referred this issue to a larger bench very recently,
Lordship, I have not come across Lordship.
very recently.
We may
I
confirm.
have to find out Lordship.
We'll have to
Uh,
find out, you know.
I have read it in the last week,
Time is
perhaps.
given for us to just verify your lordship.
If there is some outcome, Lordship, maybe.
Yes.
Just a cue, Lordship. When did your Lordship?
Any,
A week back.
Week back.
Week back.
just few days time so that both of us can,
It can be any day in the next week, Lordship.
except for Monday, 23rd, I will be out of town. Any day thereafter, your lordship, I'll be here.
Okay.
Can it be on Wednesday or
Yeah, that's about-
No problem.
Lordship?
No
I
problem.
will just verify, Lordship.
Means Starline, both these judgments, your lordship, have been referred.
No, that
Ah.
order 21, maybe.
Heard. Okay, Wednesday.
Wednesday.
Wednesday, your
Wednesday.
lordship.
So, Doctor, you are for appellant.
I'm for the appellant, my lord.
My lord, in this case, my lord, I have been engaged, my lord, we have today the file Karanama. Newly engaged, my lord, so I need to give some time to go through the records.
Okay. Heard, Mr. Heard, Mr. M. Dotto, Learned Counsel for the appellant. Mr. Sigdar, Learned Counsel for the respondent. Mr. Sigdar submits that he is engaged today by the respondent.
That's one number two.
Respondent number 2, and he submits that he may be granted some time to prepare the case. We are allowed recessal is the matter. After 2 weeks,
After 2
correct, suggest that it
Yes.
19 March.
19th of March.
And then 16.
Make me this matter. But the ambulance have not appeared for the last 4 occasions.
Then we are going to dismiss this petition, dismiss this appeal
There is nothing in the ambulance, matter. Suit was filed after 50 years of being disposed.
after
50 years.
50 years.
50 years. That is here also, my lord.
None appeals for the appellant on call. How Mr.
8 months.
A. Iqbal, Learned Counsel for the respondent present. Mr. Iqbal has pointed out that on 2 previous occasions also, that is on 26/11/2024 and 16/12/2015, the appellant,
19/9/14 and 9/6/14.
pardon,
As well as 19/9/14 and 9/6/14.
19/9 there,
14.
no, in 19/9/2014 there,
Acha. 9/6/14 also.
then and also on 9/6/14, the appellant remain absent, remain unrepresented. And under such circumstances, and Mr. Iqbal further submits that the appeal has been filed after 50 years of disposition.
Suit was filed. Suit was filed.
Suit was filed after 15 years of disposition,
550.
and there is also no merit in this petition. But having heard the submission of Mr. Iqbal, Learned Counsel for the respondent, This court has carefully gone to the order sheets dated 26/11/2024, 16/12/2015, and 7/4/2014 and 9/6/2014, and it appears that the appellant remained absent on those dates without any stay. In view of above, this appeal stands dismissed for non-prosecution. Recess will return the record to the learned courts below.
Additional evidence. May it please, Your Worship. My lord, here I have an application filed, my lord, under Order 41, Rule 27. That was registered as IA civil number 88 of 24.
Yes, it has already been ordered that it will be considered at the time of hearing.
At the time of hearing. Now, my lord, here what happened, my lord? Actually,
No, are you ready? Both the parties are ready to argue the matter today.
But this petition has not served upon me.
Which one?
This I.
I'll supply my lord copy.
I don't know actually what petition he has filed.
Okay.
Serve a copy, my lord.
Heard Mr. M.S. Sheikh, learned counsel for the appellant, Mr. L.K. Bora, learned counsel for the respondent. Mr. Sheikh submits that one interlocutory application was filed by the appellant under Order 41, Rule 27 of the CPC, and by order dated 25/1/2024, this court has ordered that the said petition will be considered at the time of final hearing of the appeal. Mr. Bora, learned counsel for the respondent, however, submits that a copy of the interlocutory application has not yet been furnished to him. At this instance, Mr. Sheikh, learned counsel for the appellant, undertakes to furnish a copy of the same to Mr. Bora during the course of the day. Place the matter after
Within-
1 week or 2 weeks.
Within the day itself, my lord, I'll serve.
Today
A date-
itself.
A date may be fixed.
Today itself, you serve a copy to him.
Yes, my lord. Today, a date may be fixed, my lord.
Okay.
17 March. Oblige.
Yes.
24 of March. Oblige, Your Worship. Okay, the phone number for me.
Mr. Chaudhary, you work for the appellant.
Yes, sir.
Respondent side?
21.
Wait for you.
Please mute yourself. It is not your item. Please mute yourself.
I'm so sorry. I'm so sorry.
Any other date, Lordship?
Heard Mr. R.S. Chaudhary, learned counsel for the appellant. None appears for the respondent on call. Leaves the matter after 1 week.
Obliged.
Item 20.
Hey, please, Your Honor. Initially, we had filed a CRP against two impugn orders. One to allow us to file written statement, and second impugn order was to allow us to cross-examine the PWs. Second prayer was allowed by Your Honor, Your Lordship. And in the very petition, we have in paragraph 6, Your Lordship comes to page 7 of the IA. Of the review petition, Your Lordship. Paragraph 3. Has Your Lordship got it, Your Lordship? Page 7, paragraph 3, Your Lordship.
Paragraph number?
3, Your Lordship.
Hmm.
In the main CRP, we have stated that the petitioner side has given me the copy on 2/5/2024. However, in the order, Your Lordship, it has been reflected as 2/4/2024, Your Lordship. And as per Rule 10 of the Land Grabbing Act, 14 days is granted. And Your Lordship has counted the date from 2/4/2024 and stated that already 14 days has lapsed. But however, in paragraph 6, we have stated that we have received the copy on 2/5/2024. And the order was passed on 4/5/2024. If Your Lordship comes to page 14 of the judgment.
Yes.
Page 17, Your Lordship. Paragraph number 4. May I read it, Your Lord?
Yes.
Mr. Dr. Learned Senior Counsel for the petitioner submits that the impugn order dated 4/5/2024 and 5/10/20 suffers from manifest illegality, and while passing the order dated so and so, the Learned Tribunal has not considered Rule 10 and thereby debarred the petitioner to file their written statement, and if it had failed to take note of the fact that while serving the notice upon the petition on 22/3/2024, the legible copy of the documents has not been furnished to the petitioner, and the same were furnished on 2/4/2024, ought to have been 2/5/2024, Your Lordship. And there are 2/5/2024. We have stated in our CRP petition, Your Lordship, in paragraph number 6. Page number 11 of the CRP.
Paragraph number?
11. Page number 11, paragraph number 6 of the CRP, Your Lordship.
So only this date is referred to be.
Yes, Your Lordship. And if you count the date from 2/5/2025, it is only 2 days, not 14 days, Your Lordship.
Heard Mr.
J. Das, Your Lordship.
Learned counsel for the petitioner. This review petition under section 114, reviewed order 46, rule 1. No, sorry, 47, rule 1 of the Code of Civil Procedure. The petitioner has prayed for review of the order dated 22/11/2024, passed by this court in CRP IO number 483 of 2024. Mr. Das, learned counsel for the petitioner, referring to the order under review dated 22/1/2024, submits that in paragraph number 4, in respect of the submission of the counsel for the petitioner, this court was pleased to record that the legible copy of the document had not been furnished to the petitioner, and the same was furnished on 2/4/2024, whereas the said date ought to have been 2/5/2024.
Yes, Your Lordship.
And the same has clearly been reflected in the petition, a main civil revision petition at paragraph number 6. And if that date is counted, then there is no delay in filing the petition.
Yes, Your Lordship.
Filing
Because
the
the order was passed on 4/5/2024.
And as such, Mr. Das has contended to allow this petition by modifying the date, that is 2/4/2024, in paragraph number 4 and subsequent paragraphs and in subsequent paragraphs. But having heard the submission of Mr. Das, learned counsel for the petitioner, this court has carefully gone through the petition and the documents, lesson record, and also perused the order dated 22/11/2024, and also the paragraph number 6 of the CRPIO number 483 of 2024. Accordingly, taking note of the submission of Mr. Das, learned counsel for the petitioner, this review petition stands allowed. The date, that is 2/4/2024, as mentioned in the paragraph number 4 and in all subsequent paragraph, shall henceforth be read as 2/5/2024. 5/2020. In terms of this,
Your Lordship,
revision petition stands allowed. Review
in
petition.
view of the above, I may be allowed to file my written objection, Your Lordship, because in view of the above correction, I may be allowed to file my written objection. Because it has to be filed within 14 days, and we have received the copy only
No,
2
no,
days prior.
the question of allowing here does not arise. Here only to review the order.
No,
We have reviewed the order.
no, if that be so, Your Lordship's observation in paragraph number 4, since already 14 days has passed, 2/4/2024. On such direction, on such observation, my written objection was not taken into consideration, filing of written objection, Your Lordship.
Okay.
Because
In view.
Your Lordship, if I may be allowed to clarify one thing, Your Lordship.
Take down. Since the written statement, since The legible copy of the document was furnished to the petitioner on 2/5/2024 as per Rule 10 of the Rule 2013. A written statement has to be filed within a period of 14 days. And the written statement was filed by the petitioner on,
It was not filed. My prayer
No.
taking time was rejected only after 2 days of receiving the copy by the order dated 4/5/2024.
and that being so, the period of 14 days has to be counted with effect from 2/5/2024. The petitioner has filed the application on 4/5/2024 for extension of the time, but the same was rejected. Since the period of 14 days has to be counted from the date of from 2/5/2024, the period of 14 days, the application filed by the petitioner on 4/5/2024 was within the stipulated period. In that being so, the petitioner is allowed to file the written statement before the learned tribunal. And on such written statement being filed, the learned tribunal shall accept the same and proceed with the case in accordance with law.
Deeply obliged, Your Honor.
Item number 21 by Vishnu.
Dear plead your lordship. Lordship, this matter is led by my senior Sri Kiran Chaudhary. He is on legs in court number 1. Lordship, may I pray to take up this matter some other day?
Lordship, I'm so sorry I'm appearing virtually because of my injury on hand. Lordship, I will request you to fix it on a day, maybe on 5th of March, Lordship.
Yes.
5th March is not possible, Lordship. 14th
14 March.
14 March.
Yes.
Oh, 14. Saturday is open. Second, how? 16. 16.
Monday, it's beginning.
Tuesday, 17. 17.
Yes, 17 would be convenient for you.
Yes, Lordship, that's okay, Lordship.
Okay. Heard Miss R. Kakoti, learned counsel for the appellant. And Mr. Your good name, please?
Sir, I am Devojit Borkakoti.
Devojit Borkakoti for the respondent. Ms. Kakoti, learned counsel for the appellant, submits that conducting counsel Mr. Kiran Chaudhary is busy in another court and she pressed for adjournment of the matter, and accordingly taking note of the submission of learned counsel for both the parties, the matter is then adjourned to be listed on 17th of March.
Much obliged, Lordship.
Number to 9.
Much obliged.